I want to introduce Lindsey Burke. Lindsey is the director of Center for Education Policy at the Heritage Foundation. She oversees the foundation's research and policy on issues pertaining to preschool, K-12, and higher education reform. Her commentary, research, and op-eds have appeared in numerous magazines and newspapers, and she frequently speaks on education reform across the country and internationally. She has published evaluations of education choice options for public policy foundations across the country and has done extensive work developing and evaluating education savings accounts. She is one of the most renowned experts on this in the country. She also has and may have more, but I know of Jason Bedrick, who used to join us on these calls, who now works, he was at EdChoice and now works with Lindsey, and then Jonathan Butcher, who has also been a pioneer in this. So their organization is one of the leaders in this, if not the #1 leader. So with all of that, Lindsey, thank you for joining us today.
Well, thanks, Craig. Appreciate that, and appreciate being able to talk to all of you today. And one of this, I guess, is the inaugural meeting of the group. So really happy to be here to talk a little bit about something that, as Craig alluded to, has been our #1 priority, certainly within our Center for Education Policy at Heritage, but even Heritage is an institution now putting education as its top priority, quite frankly, over the next few years. So it really has been something that we have worked on since the inception of education savings accounts in 2011, and really looking forward, it will continue to be one of our top priorities. So I just want to cover a few different things today that Craig had asked to cover that I think is an important context as you try to hopefully make this happen in Virginia. So ESAs, if we think about the history of education savings accounts, it's been amazing how quickly we have seen states adopt ESAs, a policy that no one had heard of or thought about really up until that point in 2011, has now been adopted rapidly by 8 states. And those 8 states, by the way, a good number of them circle around the state of Virginia right now. We are to the point where families in Virginia can look west, they can look south, right? They can look to Tennessee and North Carolina, and they can look to West Virginia. They are surrounded by states that have education choice. And yet when they look around the Commonwealth, have very few options for education choice themselves. So I think that's something that we have to stress over and over again. But how did we get to where we are today with ESAs? ESAs, as I mentioned, have really come to the forefront pretty quickly. If you go all the way back to 1955, when economist Milton Friedman first put out his original essay, The Role of Government in Education, that's where we first saw the idea of what would come to be known as school vouchers operationalized. So in that essay, Friedman said, separate the financing of education from the delivery of services. Yes, publicly fund education, but that does not require government delivery of schooling. And so that was the first time it was really articulated in a formal way, but it really remained an academic idea until the 1990s. In the 1990s, we see a few states, Ohio, Pennsylvania, begin to adopt education choice options, tax credit scholarship programs. Ohio gets a voucher option, but still very few options throughout the 1990s. And then if you fast forward, so about the year 2000, we had, I think at that point, 4 states with some form of choice program. So still very little in the realm of education choice in 2000. Fast forward to 2011, and this was ultimately deemed the year of school choice. And that was the Wall Street Journal. And I emphasize their school choice because we saw so many states expand voucher and tax credit options, sort of the traditional school choice modes that we had seen up until that point. But we also saw in 2011 a shift from school choice to education choice. And we saw that with Arizona adopting the first in the nation education savings account program. And so what that does is in Arizona, they said, as a student, if you qualify, and at the time it was only open to students with special needs, but every year they've had the ESA program in operation, they have expanded it to additional populations of eligibility because it is so popular. But that first year, if you were a child with special needs, you could receive 90% of what the state, and remember, this is only state funds, it's no federal money, it's no local money, 90% of what the state would have spent on your child in the public school directly into your education savings account. And at that point, you could use those dollars to pay for any education-related service or product or provider. So that would include private school tuition, online learning, special education services and therapies, curricula, textbooks, anything that you needed to be successful as a student. And what was innovative is you could roll over unused ESA dollars year to year, and you can even roll them into a college savings account. And so that was a really important, if anybody knows Matt Ladner out in Arizona, he always talks about how it was a critical refinement of that original Milton Friedman voucher idea, the ability to roll over those dollars and to direct individual dollars to multiple education products and services, right? This is the big distinction between a voucher, which is basically a coupon to pay tuition, in an education savings account, which is more like an Amazon gift card, right? You can shop around any sort of store or product that's available on Amazon, you have access to. And so it's much, much more flexible. And so we see Arizona adopt this ESA model in 2011. And then after that, we see Florida follow suit in 2014. Then we see states across the country start to run with it: Mississippi, North Carolina, Tennessee, and most recently, West Virginia. West Virginia's program is notable, so notable, because it is the first in the country of any type of education choice program that is operational to be a near universal choice program. And it is even better because it happens to be an ESA. So we have our first ever near universal ESA. We have to say near, we can't say universal yet because it is only open to students who are currently enrolled in public schools. So if you're already enrolled in a private school, you cannot access the ESA as of yet, at least. But right now it's open to all kids in public schools, which is well north of 90% of the West Virginia student population. They just opened their enrollment period. They had 3,000 families right off the bat say that they wanted to go ahead and participate. So it was really good to see that uptake right away. But West Virginia is so important because it shows that you can get a near universal program in place. A lot of folks will start off and say, well, we need to target these options to just kids with special needs or families who are low income, put that income cap on it. Remember, we don't means test public schools, right? No matter how wealthy you are, you can enroll your child in a public school. Bill Gates can send his children to public schools. We should not means test education savings account dollars either. And so West Virginia has demonstrated that this is possible. And recall, just a few years ago, they had a massive Red for Ed movement that put a stop to even a very modest ESA option for kids with special needs, very, very small program, and put a stop to charter schools becoming a reality in West Virginia. That was just a few years ago. They well overplayed their hand, and now West Virginia has a universal ESA option in place. So we're really just seeing ESAs go gangbusters in states across the country, and really having done so very rapidly over the past decade. A couple of other things I wanted to touch on that Craig was interested in. Virginia, the situation that Virginia is in now, of course, as everybody has alluded to already, the Senate's out of play at the moment. I'll leave the politics of all that to Craig and Chris and everybody else, but we know how close Virginia came a few years ago, right? McAuliffe vetoes a bill that would have created ESAs, by the way, on the grounds that it would have violated the state's Blaine Amendment. And I do want to say a couple of things about that in a second. And then we see the same thing again in 2017 with Ralph Northam casting the tie-breaking vote in the Senate to kill that bill as well. But we have gotten so close. And so, of course, in the near term, it's going to remain, as Craig alluded to, an uphill battle. But it does show that we are close. And I do think it's possible, particularly with this group that Craig has pulled together. On that, just really quick side note, as you all know, and Chris had sent out a note about this yesterday, the tax credit scholarship program is now in jeopardy in Virginia as well. The legislature had passed a budget cutting that program by more than half. As I understand it, and Chris can speak to this better than I can, but the governor can still amend or veto specific provisions in that budget. And I think how that ends up playing out is going to be really instructive for the future of education freedom in Virginia, the future of ESAs in particular. As I mentioned, I did want to say a few quick things about the legal landscape. I know just, from years of having worked with all of you in Virginia, that this is something that comes up over and over again. Is education freedom even tenable given Virginia's Blaine Amendment in the state constitution? Look, the Supreme Court is primed any minute now to rule that states cannot discriminate against parents and students who want to effectively practice their religion through their choice of K-12 school. We think it's likely that the court will invalidate a Maine law that prohibited families from using state funds for private religious affiliated schools when a public school is not available in that area. This is the Carson v. Macon decision that's currently before the court. I expect it to be handed down probably, I don't know, if I were to guess, maybe next week even. So we're prepared for that. But what that looks at, so if you look at Maine right now, their private education choice program prohibits families from taking their dollars to private religious schools. So that prohibition discriminates against religious families and really contradicts the Espinoza decision that the Supreme Court handed down back in 2020. If you recall, in Espinoza, the Supreme Court held that preventing school choice families from taking their children's education dollars to private schools just because they were religious violated the free exercise clause of the First Amendment. And if you read that decision, the really important point there was something that Chief Justice Roberts had said, which was that a state need not subsidize private education, but once the state decides to do so, it cannot disqualify some private schools solely because they are religious. And so that was Espinoza. Despite the Espinoza decision, the first Court of Appeals ruled against the families in Maine and their program, arguing that Maine's program does not discriminate based on a school's religious status, just based on religious use. So this is the distinction before the court right now in Carson v. Macon. And so, in other words, basically, whether the scholarship or education funds can go to a school that is primarily religious in nature, or whether those funds may go to a school where they are put to religious instructional use. And to our mind, that's a distinction without difference, and families that are seeking to participate in otherwise available public programs should not be forced, cannot be forced to surrender their values in order to do so. All of that, I think, is important for how we think about the future of education savings accounts in Virginia in particular, because we have gone from Zelman v. Simmons-Harris in 2002, which said states can allow private religious schools to participate in their education choice programs, to 2020 with Espinoza, which said if a state subsidizes private education, it must allow private religious schools to participate, now to Carson v. Macon, which hopefully will end up saying that states must allow scholarship funds to also be put to religious instructional use. So I say all of that to say that the effect of all of these decisions will be to completely neuter Blaine amendments, including the Blaine Amendment found in Virginia's Constitution, which basically says public money cannot go to religious schools. So I think within a matter of a week, perhaps, that the Blaine Amendment question will be rendered utterly moot for purposes of education freedom in Virginia.